event of our Law Week program, which is dedicated to the subject of same-sex marriage in law and society. My name is Bruce Dutu. I'm on the faculty here at Dartmouth, professor of Native American Studies, and I'm also serving as convener of the Legal Studies faculty group here at the college. In introducing our keynote speaker at yesterday's keynote address by Professor Nancy Polikoff, Dartmouth professor of philosophy Susan Bryson reminded us that Law Day dates back to the administration of President Dwight Eisenhower. President Eisenhower designated May 1st as Law Day, in part acknowledging that, quote, a day of national dedication to the principle of government under law would afford us an opportunity better to understand and appreciate the manifold virtues of such a government and to focus the attention of the world upon them. He also noted that it was, quote, fitting that the people of this nation should remember with pride and vigilantly guard the great heritage of liberty, justice, and equality under law which our forefathers bequeathed to us. It's also worth noting that the American Bar Association is celebrating this year's Law Day in honor of Abraham Lincoln, with the theme of A Legacy of Liberty, celebrating Lincoln's bicentennial. In his letter to the association's membership, ABA President Thomas Wells, Jr. highlighted Lincoln's constant appeal, quote, to the fundamental values of human equality, justice, and liberty as set forth in our nation's founding documents as among the most enduring features of Lincoln's legacy. The themes of liberty, equality, and justice, and the legal arguments that underpin them, are certainly prominent elements in today's debates surrounding the issue of same-sex marriage. We're fortunate to have with us three prominent academics whose work in the public sphere, in scholarship, and in the classroom have served to illuminate and to advance our knowledge of the broader social, legal, historical, and cultural dimensions relating to same-sex marriage. Before introducing our panelists, I'd like to express my appreciation and thanks to the organizations and individuals who have helped to bring this program together. We thank the faculty members of the Legal Studies program, most especially Professor of Philosophy Susan Bryson, for helping to conceive of this program last year and for their support throughout the planning. As a side note, I'd like to take credit for being so prescient that this would be a hot topic issue, but we voted on this last summer, and lo and behold, it has become a very, very timely event for all of us. We're indebted to the Dartmouth Lawyers Association, especially to leaders Lanny Kurzweil, Hal Rabner, and Ted Little for their generous support, encouragement, and active participation in helping to bring you this year's Law Day program. We acknowledge with gratitude the support and co-sponsorship of the Dartmouth Gay, Lesbian, Bisexual, and Transgendered Alumni Association, as well as the Office of Pluralism and Leadership. The Office of Alumni Relations, especially Stephanie Chestnut and Joni Radu, have provided immeasurable support and encouragement. We acknowledge and thank the Office of Public Affairs, notably LaTarsha Gatlin and Roland Adams, for their help and support on publicity for this event. And finally, we thank the Rockefeller Center, especially events coordinator Judy Fothergill, for her active support and leadership throughout this process, especially in organizing yesterday's keynote Aaron lecture. And now for our program for today. I will introduce our panelists all at this time, and as they give their remarks, we'll hold questions until all three panelists have made their presentations, and we hope to allow sufficient time for you to engage in some questions in the last half hour of today's program. Our first speaker is Professor of Law Greg Johnson. Greg is the Director of the Legal Writing Program and Professor of Law at Vermont Law School. Greg is an expert in sexual orientation and the law, Native Alaskan legal issues, law of Pacific Islands, and appellate advocacy. Professor Johnson earned his AB degree from Cornell University and his law degree from Notre Dame Law School. His legal practice experience includes work as a law clerk to various courts, including the Alaska Supreme Court. He joined the Vermont Law School faculty in 1997. Professor Johnson has spoken about and written widely on the rights of same-sex couples and has testified before both houses of the Vermont legislature when it considered landmark civil unions legislation several years ago. Most recently, he testified before the Vermont Senate Judiciary Committee when it considered the recently approved legislation recognizing the rights of same-sex couples to marry. Greg's topic will be, "We've heard this before, the legacy of interracial marriage bans and the implications for today's marriage equality debates." The second speaker is Professor Jackie Gardena, Associate Professor of Law at Vermont Law School, who specializes in the field of civil procedure, administrative, and bankruptcy law. She's active with national and regional organizations that work for the advancement of legal rights for gay, lesbian, bisexual, and transgendered persons, and is particularly active in efforts to seek repeal of the military's Don't Ask, Don't Tell policy. Professor Gardena earned her bachelor's degree in political science from the University of Iowa, her master's degree in social work from Boston University, and her law degree from Boston College. Following a brief career in private practice and adjunct law teaching, Professor Gardena joined the law faculty at Vermont Law School in 2003, where she quickly earned recognition as one of the faculty's most accomplished teachers. In fact, Jackie has pretty much had a lock on the VLS Student Bar Association's Faculty Service Member Award, the school's equivalent of the Outstanding Teacher Award, winning this honor every academic year from 2004 to last year. And I think she's a sure bet to get it again this year. She did. Congratulations again. She is the faculty advisor to the Alliance Student Organization, which supports gay, lesbian, bisexual, and transgendered students and their programs at Vermont Law School. Her topic today is In Defense of Marriage, Did Congress Go Too Far? Finally, we'll hear from Professor Brian Gilley, Assistant Professor of Anthropology at the University of Vermont. Dr. Gilley's research focuses on the theoretical and cultural logic of social acceptance, particularly as it relates to issues of identity, health, and the body. Dr. Gilley holds a PhD, a master's degree, and bachelor's degree in sociocultural anthropology from the University of Oklahoma. His recent book, Becoming Two-Spirit, Gay Identity and Social Acceptance in Indian Country, published by University of Nebraska Press in 2006, documents the ways that Two-Spirit Native American males challenge their alienation from mainstream Native and tribal society. Looking at the relationship between power, difference, and agency, this research investigates the ways in which Two-Spirit men actively construct their cultural and social identity in response to historic gender ideology, contemporary popular gay culture, tribal identity, and mainstream ideas about Indianness. Dr. Gilley's topic for today is entitled Liberal Activism and the Uses of American Indian Gender Diversity in the Same-Sex Marriage Debate. So, without further ado, Professor Johnson. Thank
you. I'd like to first thank Bruce, my friend Bruce, Professor Dutu, for inviting me to speak for Law Day, and to everyone else who helped put this day together. It's just been a real pleasure working with you, getting it all together, and I'm honored to speak at Dartmouth, so thanks very much for the invitation. Is it fair to compare bans on interracial marriage to bans on same-sex marriage? Courts have wrestled with this question since the inception of the debate on same-sex marriage. The first same-sex marriage cases were filed soon after the United States Supreme Court's 1967 decision in Loving v. Virginia, which struck down interracial marriage bans in Virginia and 15 other states. The court stated boldly, marriage is one of the basic civil rights of man. Same-sex couples argued that this broad language applied to them as well. The early same-sex marriage cases all rejected this analogy. The Minnesota Supreme Court, in the first same-sex marriage case in 1971, dismissed the comparison in a single sentence, which, to the court, seemed so self-evident that it did not need a citation. Quote, in a common sense and in a constitutional sense, there is a clear distinction between a marital restriction based merely upon race and one based upon the fundamental difference in sex. In recent times, however, courts have used loving to support the constitutional claim to marriage. This happened in California as well as Connecticut. The academic community has also debated the relevance of the old bans on interracial marriage. Some agree with Professor Peggy Pascoe that it is virtually impossible to understand the current debate over same-sex marriage without first understanding the history of American miscegenation laws and the long legal fight against them. On the opposite end, the late Professor David Coolidge, a noted opponent of marriage equality, accused those who use the analogy of, quote, playing the loving card in an attempt to slander with the brush of bigotry. Gay rights advocates are split on the merits of the comparison. Some fear that the sameness argument risks contributing to injustice and alienating potential supporters in the African American community by ignoring the differences between the two civil rights struggles. As Professor George Chauncey has said, claiming the two experiences have been the same does no justice to history and no service to the gay cause. I certainly agree that supporters of marriage equality must make an independent moral claim as to why same-sex couples should be allowed to marry. At the same time, my study of the bans on interracial marriage and the cases that upheld them has convinced me that the earlier struggle for marriage equality is relevant to today's debate. In 1948, the California Supreme Court, in the Perez case, became the first high court in the country to declare unconstitutional a state's ban on interracial marriage. Advocates like Beth Robinson have used the Perez case to great effect in arguing for same-sex marriage. Far more fascinating to me, though, are the many, many cases before 1948 which upheld bans on interracial marriage. To prepare for today's talk, I had the unpleasant task of immersing myself in this disturbing jurisprudence. The arguments made in these cases are strikingly similar to arguments made today against same-sex marriage. These arguments include religion and natural law, procreation, concern for the children, deference to the legislature, and the slippery slope argument. The ultimate rejection of all these arguments in the interracial marriage context may speak to their long-term viability in the same-sex marriage debate. First, courts firmly believe that interracial marriage was unnatural and against God's plan. In Loving, the Virginia trial court famously concluded, Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for them to mix. Yet Virginia was far from alone in holding this view. So many courts relied on God's plan and natural law that one commentator has said judges formed a virtual chorus on this issue. Some courts quoted the Bible directly. Others, like the Pennsylvania Supreme Court, expressed wonderment at God's plan. Why the Creator made one white and one black, we do not know. But the fact is apparent, and the races are distinct, each producing its own kind and following the peculiar law of its own constitution. The natural law, which forbids their intermarriage, and that amalgamation which leads to the corruption of races, is as clearly divine as that which imparted to them different natures. Courts considered race restrictions part of the very definition of marriage, decreed by God himself. Here is the Oklahoma Supreme Court's rationale. Statutes forbidding interracial marriage by white and black races were, without doubt, dictated by wise statesmanship and have a broad and solid foundation in enlightened policy, sustained by sound reason and common sense. The amalgamation of the races is not only unnatural, but it is always productive of deplorable results. These words were not the words of some hysterical outlier. This was the reasoned judgment of respected jurists across the country in case after case. Courts also defended bans on interracial marriage out of concern for racial integrity. The Virginia Supreme Court upheld the law, which the United States Supreme Court later struck down, out of a concern that interracial marriage would, quote, corrupt the blood and lead to, quote, a mongrel breed of citizens. Another court opined that offspring of these unnatural connections are generally sickly and effeminate. Perhaps the strangest procreation argument came from a judge on the Missouri Supreme Court, who said, if the issue of black men and white women, and of a white man and a black woman intermarry, they cannot possibly have progeny. And such a fact sufficiently justifies the laws which forbid the intermarriage of blacks and whites. The Georgia Supreme Court succinctly summarized the sentiment of essentially every court to consider this issue before Perez, when it said, interracial marriages are productive of evil, and evil only, without any corresponding good. Arguments about racial integrity are, of course, procreation arguments, yet with an opposite result from the procreation argument made today. In a racial marriage, interracial couples should not be allowed to marry because they can procreate, and same-sex couples should not be allowed to marry because they cannot procreate. Which is it? Early same-sex marriage cases and many interracial marriage cases accepted the procreation argument. Later courts, including the Vermont Supreme Court, have rejected it, and with good reason. As the California Supreme Court said last year, the constitutional right to marry has never been viewed as the sole preserve of individuals who are physically capable of having children. Another argument used against interracial marriage was the slippery slope. Defenders of traditional marriage back then worried that allowing interracial marriage would lead to, as one court put it, the father living with the daughter, the son living with the mother, and the Turk and the Mohammedan, with his numerous wives, establishing his harem at the doors of the Capitol. When the California Supreme Court struck down that state's ban on interracial marriage, it had to defend its decision against charges that allowing interracial marriage would lead to polygamy. It has been 60 years since the California decision. Striking down the ban on interracial marriage obviously did not lead to polygamy or fathers marrying daughters. Perhaps the same specious argument can now be laid to rest in the same-sex marriage debate. Given the close parallels between bans on interracial marriage and same-sex marriage, opponents of marriage equality today are sensitive to this issue and have tried a number of arguments to distance their position from the earlier laws. They like to depict the bans on interracial marriage as a leftover of slavery, more a manifestation of white supremacy than an expression of the real meaning of marriage. The real issue was race, they say, with marriage caught in the middle. Critics have also suggested that the bans on interracial marriage were the product of the misguided eugenics movement of the 1920s, a temporary, failed experiment grafted on to the basic definition of marriage that did not include a racial component. These arguments distort the long-standing and universal nature of the bans on interracial marriage. These bans are about so much more than race and white supremacy. They spoke to all of America's core conception of what marriage was. Bans on interracial marriage date back to the colonial period. Maryland banned same-sex interracial marriage in 1663, and other colonies soon followed. In 1948, at the time of the Perez decision, 30 of the 48 states banned interracial marriage, some by constitutional amendment. Opponents of same-sex marriage argue that interracial couples could still get married in some states, suggesting that the racial component of marriage was not as central to the definition of marriage then as the gender component seems to be today. Yet courts at the time were quick to point out that the only states which did not prohibit interracial marriage were those with little or no racial minority population, and therefore presumably those with nothing to worry about. This would describe Vermont today, but especially in the 18th and 19th centuries. Vermont never banned interracial marriage, but it did have an evasion statute which prevented couples from coming to Vermont to get married if their own state banned the marriage. The evasion law served as Vermont's equivalent to a ban on interracial marriage, since that was its practical effect. All across America, people understood marriage to be a sacred union within one's race. In 1958, 10 years after Perez, a Gallup poll determined that only 4% of Americans approved of interracial marriage. That number had inched up to 20% in 1968, a year after Loving, but both those percentages are way lower than the percentage of Americans who currently support same-sex marriage. The white supremacy argument might work for the South, but states across the country, not just those with Jim Crow laws, banned interracial marriage, and many of the courts across decades and centuries upheld these laws. I doubt that opponents of marriage equality now would say that in 1958, 96% of Americans were white supremacists. No, the answer closer to the historical truth is that essentially all Americans, good people and not, racist and otherwise, simply understood marriage to include a one-race requirement. This principle was central to the definition of marriage. It was ordained by God and was wise social policy for the family and the country. The many cases upholding bans on interracial marriage were simply a reflection of the accepted definition of marriage. When Professor Coolidge says that in the Loving litigation, the Virginia courts were trying to redefine marriage for their purposes, thereby distorting its genuine meaning, he is playing the Loving card and mischaracterizing the record. The exact opposite is true. Courts not only in Virginia but across the country were upholding a traditional definition of marriage that predated the founding of the country. They were defending the traditional definition of marriage against activists who sought to redefine marriage. What to make of this tainted jurisprudence? Short of any use in the struggle for marriage equality today, these cases are to be appreciated in their own right as a fascinating and upsetting historical account of a different America. The words in these opinions are hurtful. Lines like, "The separation of the races is an undeniable fact, and all social organizations which lead to their amalgamation are repugnant to the laws of nature," hit you like a sock on the jaw. How could we be so wrong? One conclusion seems irrefutable. These cases prove that our understanding of equal protection and the fundamental right to marry does evolve over time. As recently as 1948, suggesting that interracial couples had a constitutional right to marry would have been radical, even risible. The arguments against interracial marriage were embraced by dozens of courts across the country. Yet today, these arguments have been thoroughly discredited and are now rightfully held in disgrace. Time will tell how similar arguments will fare in the ongoing same-sex marriage debate. It is not necessary to claim that homophobia is as bad as racism, or that lesbians and gays have been discriminated against in the same way as people of color, to make the legal comparison between the two movements for marriage equality. I agree with Professor Catherine Smith that on the political and social fronts, the compelling message for LGBT advocates to build alliances with black communities is not one of sameness, but one of common interest. The sameness argument, however, should be used in court, regardless of its impact on relations between communities. Courts operate by stare decisis. Like cases should be decided alike. Precedent binds. The same arguments were made then as are made now. Their descent from renown to ignominy in the interracial marriage context should cast some doubt, or at least put in perspective, their relative merits in the same-sex marriage context. I agree with Professor Adele Morrison's take. Groups may disagree about the context in which Loving's holding may apply, or may argue that it has been misinterpreted or even misused. However, to say that Loving cannot be used at all because one group disagrees with its usage by another is counter to the very purpose of legal precedents and reasoning by analogy. Mildred Loving passed away last year at the age of 68. Richard Loving died tragically in a car accident in 1975. But Mildred Loving was lucky enough to see her children and then her grandchildren grow up in a country with a radically different view of marriage than when she and Richard were sentenced to 1 year in prison for having the audacity to marry the person they loved. All the worries about the end of marriage and the end of society, should interracial couples be allowed to marry, were obviously misplaced. Marriage was not destroyed or weakened by allowing interracial couples into the institution. It was strengthened. Personal liberty was enriched, and the social compact made firm by extending marriage to interracial couples. Mildred Loving knew this, and she believed the same arguments made today against same-sex marriage fared no better. I will let her have the last word. Here's what Mildred Loving said in 2007 on the 40th anniversary of Loving about using her case in defense of marriage equality today. "My generation was bitterly divided over something that should have been so clear and right. The majority believed what the judge said, that it was God's plan to keep people apart. Not a day goes by that I don't think of Richard and our love, our right to marry, and how much it meant to have that freedom to marry, the person precious to me, even if others thought he was the wrong kind of person for me to marry. I believe all Americans, no matter their race, no matter their sex, no matter their sexual orientation, should have the same freedom to marry." Thank you, Mildred, and thank you, Dartmouth.
You'll see the top of my head and that's it. So with your permission, I'll just stay here. I want to extend my thanks as well to all of you for coming in out of the sunshine, and for Dartmouth, and especially Bruce Dutu for inviting me to participate. As Bruce said, the title of my presentation is "In Defense of Marriage, Did Congress Go Too Far?" Today I'm going to be talking about the Federal Defense of Marriage Act and the constitutional questions it presents. Although my presentation is titled as a question, I must confess at the outset that I won't be providing a clear answer. There is never a clear-cut answer to whether a particular law is constitutional or not. It depends on the social and political context, the makeup of the bench, and how the case is legally and factually framed for the court. What is constitutional changes with time. One need only look at the segregation cases to understand that social and political contexts mean a great deal in defining constitutional rights. In Plessy v. Ferguson, the court held that separate but equal was constitutional, but in Brown v. Board of Education, they held quite the opposite. More recently, and perhaps more relevant to our discussion today, we saw the court do a similar about-face on the issue of whether the state could criminalize private sexual relations between consenting adults, when in Bowers v. Hardwick, the court upheld a Georgia sodomy law, and then 17 years later, in Lawrence v. Texas, the court declared a similar law unconstitutional. The language of the Constitution didn't change between these cases. The equal protection and due process clauses remain the same, so the shift can only be attributed to something external to the document. The court reached a tipping point of sorts, something that altered the constitutional analysis. Conduct that was once perfectly acceptable, segregation of the races, became unconstitutional to continue. And conduct that the state once condemned as morally reprehensible, sodomy, became unconstitutional to criminalize. So to answer the question, has Congress gone too far, requires us to look beyond the constitutional doctrine and examine the social and political context as well as how the issue has been framed. In examining the social and political context, we must ask whether the same-sex marriage debate is a constitutional question at all, or is it simply a culture war? Is it a battle to be fought in the courtroom or through the legislative process? Courts are loath to insert themselves into a policy disagreement appropriately resolved through the ballot box. Once the court decides that the Constitution prohibits particular legislation, the decision-making about the issue moves from the democratically elected legislature to the unelected judiciary. We often hear the outcry of activist judges when a court makes a decision regarding a hotly disputed issue, such as abortion, or more recently, when state court judges decided that their state's constitutions required equal access to marriage. The social and political context also frames the issue for the court, and in the case of same-sex marriage, the government has framed the issue as one about morality. At its base level, the state and federal government's decisions around access to marriage and its benefits are presented as moral decisions. The government has framed the issue as one about sexual conduct, not about identity or animus aimed at a particular group. And when the argument is structured around conduct, especially conduct deemed to be morally suspect, the constitutional analysis, and I would argue the tipping point, changes. So how has Congress successfully framed the debate as about sexual conduct rather than about identity? Let's first look at some background regarding the Defense of Marriage Act. The Defense of Marriage Act, or DOMA, is a law passed by Congress in 1996. Congress passed the law in the wake of a Hawaii state court decision that held that denying same-sex couples marriage licenses may, not would, but may violate the Hawaii state constitution. In response, Congress passed DOMA, a very short piece of legislation with enormous implications. DOMA essentially serves two functions. First, it attempts to prevent the spread of same-sex marriage by limiting its portability. Section 2 provides that no state is required to recognize a relationship between persons of the same sex that is treated as a marriage in another state. Second, DOMA prohibits marriage legally sanctioned under a state law from being recognized under federal law. Section 3 defines the term marriage for purposes of federal law to mean only a legal union between one man and one woman as husband and wife, and the term spouse to mean only a person of the opposite sex who is a husband or wife. As a result, same-sex couples legally married under state law are denied access to over 1,000 federal benefits associated with marriage. These include everything from tax benefits, Social Security and pension payments, to the immigration status and deportability of a non-citizen's spouse. So let's examine why Congress found it necessary to act so swiftly. Remember, in 1996, no state had declared that they were going to allow same-sex marriages. Hawaii had just hinted that it may allow it. And as it turns out, it was 4 years before Vermont allowed for civil unions and 9 years before Massachusetts actually granted access to marriage to same-sex couples. So, excuse me, I'm going to quote a bit from the Judiciary Committee report because I think the exact language of the government is important because it helps frame the debate. During the hearings on the proposed DOMA, the House Judiciary Committee and the bill's sponsors justified the law based on the federal government's interest, quote, in maintaining and protecting the institution of heterosexual marriage because the government has a deep and abiding interest in encouraging responsible procreation and child rearing, end quote. The report further stated, quote, simply defined, marriage is a relationship within which the community socially approves and encourages sexual intercourse and the birth of children. It is society's way of signaling to would-be parents that their long-term relationship is socially important, a public concern, not simply a private affair. It went on to opine that, quote, closely related to the interest in protecting traditional marriage is a corresponding interest in promoting heterosexuality, and more specifically, civil laws that permit only heterosexual marriage reflect and honor a collective moral judgment about human sexuality. This judgment entails both moral disapproval of homosexuality and a moral conviction that better comports with traditional, especially Judeo-Christian, morality, end quote. As the legislative history shows, the phrase defense of marriage is nothing more than a euphemism for defense of heterosexuality. I think many people would be uncomfortable with the fact that their marriage license is a license for state-approved sex, and the benefits associated with marriage are carrots of sort. But it's important to recognize that when the government regulates marriage, it is regulating sexuality. Marriage has become a conduit for reducing promiscuity, encouraging monogamy, and ensuring procreation occurs within a defined family unit. Sexual behavior that interferes with these goals, such as fornication, adultery, sodomy, or even the use of sex toys, have been subject to regulation and often criminalized. Marriage is, in essence, the state's sexual stamp of approval. Because the government has framed the issue as one about conduct and morality, they have also framed the constitutional question. Does the government, through its democratically elected representatives, have the authority to define and regulate what it considers to be immoral and unacceptable behavior? The answer is obviously yes. Many of our laws are based on moral judgments about behavior. Society is constantly making judgments about appropriate conduct based on its perceived effect on others. Indeed, the Supreme Court has recognized that the state has a substantial government interest in protecting order and morality. And important for our discussion today, that those decisions should be made by the legislature, not by the courts. But the government doesn't have unlimited authority to regulate based on morality. If the government were free to simply claim that a particular law was based on a moral judgment, few laws would be overturned as unconstitutional. Yet laws promoted as moral decisions have been overturned. The miscegenation laws, laws regarding access to contraception, laws regarding abortion, laws criminalizing sodomy were, and in some instances continue to be, unabashedly linked to religious doctrine. Eventually, however, the state's power was limited by constitutional doctrine. So there are limits on the state's ability to legislate sexual conduct based on morality. The more difficult question is discerning what those limits are and to determine whether the court has reached the tipping point so that it finds previously acceptable legislation unacceptable. Or to borrow a phrase from my title, it finds that the government has gone too far. So let's take a look at how laws adversely affecting gays and lesbians have been challenged. They've been primarily challenged under two clauses, the Due Process Clause and the Equal Protection Clause. While the constitutional analysis under these clauses is complex, for our purposes today, let's just assume that legislation will be presumed valid unless the party opposing it can establish that it's not rationally related to a legitimate state interest. This is a notoriously hard standard to meet. That being said, the court recently found two laws affecting gays and lesbians unconstitutional using this very standard. The court in Romer v. Evans struck down a Colorado amendment that attempted to deprive gays and lesbians from protection under anti-discrimination laws, declaring that the amendment violated the Equal Protection Clause because it bore no rational relation to a legitimate state interest and appeared, in fact, to be born only of animosity towards a particular group, homosexuals. A few years later, the Supreme Court in Lawrence v. Texas invalidated an anti-sodomy law under this standard, holding that the state had violated the petitioner's due process rights by making their private sexual conduct a crime. Justice Scalia's dissent in Lawrence should be noted as well, however, because it highlights the struggle I described earlier. Justice Scalia accuses the majority of taking sides in a culture war. He asserted that the state's promotion of sexual morality is a legitimate state interest. He took a similar approach in his dissent in Romer, viewing the disputed constitutional amendment as a rather modest attempt by the people of Colorado to preserve traditional sexual mores. And Justice Scalia's focus on conduct and morality is key to his position on this issue and will likely be key to the constitutionality of DOMA. Because he says it so well, I want to quote his dissent in Romer. Quote, "The court's opinion today contains grim, disapproving hints that Coloradans have been guilty of animus or animosity towards homosexuality, as though that has been established as un-American. Of course, it is our moral heritage that one should not hate any human being or class of human beings. But I had thought that one could consider certain conduct reprehensible and could exhibit animus towards such conduct. Surely that is the only animus at issue here, moral disapproval of homosexual conduct," end quote. And therein lies the rub. Is the electorate making a moral judgment about conduct, or is it inappropriately classifying citizens based on identity? Romer and Lawrence provide the constitutional backdrop for the three federal courts that have reviewed DOMA. Two federal courts have held that the law is constitutional, that it neither violated the Due Process Clause nor transgressed the Equal Protection Clause. In both cases, the court showed deference to Congress's decision, finding that the government had legitimate interest in promoting heterosexuality and limiting marriage to heterosexual couples. In contrast, a Ninth Circuit judge came to a different conclusion. The judge concluded that there was not a rational basis for denying benefits to same-sex spouses while granting them to opposite-sex spouses. According to this court, the denial of federal benefits to same-sex spouses cannot be justified simply by a distaste for or disapproval of same-sex marriage or a desire to deprive same-sex spouses of benefits available to other spouses in order to discourage them from exercising a legal right afforded them by a state. Now a fourth court will have an opportunity to hear a challenge to the law. On March 3rd, a not-for-profit organization called Gay and Lesbian Advocates and Defenders, or GLAD for short, filed suit on behalf of 15 Massachusetts gay and lesbian citizens contending that DOMA violates the Equal Protection Clause, specifically that the federal government is classifying married couples differently. Legally married opposite-sex couples obtain benefits that legally married same-sex couples do not, without a rationale that promotes a legitimate government interest. GLAD anticipates the case will reach the Supreme Court in 2013. As the differing outcomes in the three previous opinions show, the constitutional principles at issue here can certainly support a holding that DOMA does not infringe on the plaintiff's constitutional rights. They can also support a holding that Congress has gone too far and infringed on the constitutional rights of the plaintiffs in the Glad case. But the issue is not just whether the Constitution supports a particular holding. I submit the question is also whether the court has reached a tipping point. As I said in the beginning, what is constitutional depends in part on the social and political context, the makeup of the bench, and the posture of the particular case. While Glad case is compelling, I fear that the current court has not yet reached the tipping point. First, any decision that DOMA violates the Equal Protection Clause could have broad implications beyond the federal statute itself. It would likely be the basis for challenging states' bans on same-sex marriage. Thus, the court would potentially be taking the decision about same-sex marriage out of the hands of the states and placing it in the hands of an unelected judiciary. When the court overruled the miscegenation laws, all but 16 states had already lifted the ban. When it overruled the sodomy law, all but 14 states had already eliminated similar statutes on the books. In contrast, when it comes to the same-sex marriage debate, only 5 states, Vermont, Iowa, Connecticut, Massachusetts, and briefly California, have approved same-sex marriage. And as we know, the California voters subsequently revoked that approval. In only one of those states was the decision reached through legislative process. 43 states have either constitutional amendments or statutes defining marriage as between one man and one woman. So there's hardly a national consensus regarding equal access to marriage. Second, the government's framing of the debate as one regarding morality and sexual conduct makes the constitutional argument more difficult. While the court may be comfortable saying that the government cannot criminalize private consensual conduct, they are less likely to say it is constitutional for the government to encourage particular sexual conduct through marriage legislation. Marriage legislation is about appropriately channeling sexual conduct and creating a socially approved family unit. Third, while the court has placed some limits on the government's ability to limit access to marriage, its recent pronouncements do not suggest it will be willing to do so here, or at least not yet. While the court's opinion in Lawrence and Romer provides some helpful language, they can be narrowed and distinguished when it comes to access to marriage and its benefits. Well, the court went out of its way to note that they were not holding that a state would overstep its bounds if it denied lesbians and gays access to the rights and benefits of marriage. The justices seemed to imply that protecting the institution of marriage remained a legitimate state interest. And while the court in Lawrence held that sodomy could not be criminalized, it did not go so far as to say that the government could not encourage heterosexuality or disapprove of homosexuality through other, less onerous means. Don't get me wrong, I think the court will reach the tipping point. But to get there, I think the issue needs to be framed differently. The marriage debate needs to be shifted from the bedroom to the identities of the individuals and families affected by the laws. The outcomes in Lawrence and Romer can be attributed in part to this shift. In both cases, the court focused on the identity of the individuals affected by the law rather than the conduct those individuals engaged in. The tipping point will come when the government and the court view gays and lesbians as more than sexual beings, and when the government stops using marriage licenses as a proxy for moral judgments about sexual conduct. I look forward to the tipping point. Thank you.
First of all, I want to extend my thanks to Professor Dutu for inviting me and to Dartmouth for inviting me. It's an honor to be here, honored to be on this panel. What I'm going to shift our focus a little bit here to more of a cultural issue involved in the same-sex marriage debate. And it may be an aspect that some of you who keep track of these sort of things are not aware of, but is very much in circulation among experts and both academic and and activists who engage in social activism around same-sex marriage. I'm going to outline a couple problems that, or issues specifically related to American Indians being incorporated into this debate, American Indian culture. The first one is that there's a misunderstanding among all interested parties about tradition and the role of tradition in same-sex marriage. And when I say tradition, I mean specific individual tribal traditions and how marriage, sexuality, gender, those sorts of institutions were acted out on a daily basis within communities, and also, and one of the central pieces of this is that tradition as a daily cultural practice is being conflated to tradition as a thing that's being debated and legislated by tribes at an institutional level. So I'm going to try to make a distinction there. But also, marriage is being conceived of outside of undifferentiated social elements that make up tradition as practice. And non-native activists appropriate native cultural history to formulate their arguments for same-sex marriage among non-natives. Natives are often held up as an example of a pre-modern natural sexuality that existed without rules, regulations, and as sort of a gender and sexuality free zone, which is a sort of liberal activist dreamland, akin to how radical fairies have used Native Americans to support their socio-political agenda. I argue that the use of American Indian cultural history by liberal activists is a form of recolonization or resettlement, akin to colonialism. So in order to understand my basic argument, we need to examine what is the nature of tradition historically, the nature of which tradition, gender traditions were built on. And so I'm going to do a short little explanation here about the difference between undifferentiated social elements and differentiated social elements. One of the key things when you look at cultural history among American Indians, and again, how this was acted out within each tribe is going to be different. And so this model or this discussion doesn't necessarily pinpoint distinct tribal differences, but it's very general in explaining the things that kind of make Native America hang together as a group of people. But one of the central things is that in a model of a society that exists in undifferentiated cultural elements, all aspects, all institutions are interrelated. And this is kind of one of the cheesy things that people latch on to. You know, Native peoples love Mother Earth and all things are interrelated and so forth. But it's more specific than that. One important thing here is that each institution that an individual interacted with fed the other institution. So, for example, here I have religion as an example that influenced kinship, which then related to politics, which related to your gender role, which then related to war. So war was in and of itself a religious act. And as you sort of, if you could rotate this model and you put war at the bottom, then once that is fed through the cultural logic, then that gets expressed in terms of a social institution or an individual's place within a social institution. So this is a key element in understanding from where we're drawing ideas about American Indian tradition and its relationship to gender, sexuality, and same-sex marriage. So when we're talking about traditions of gender diversity among American Indians, the acceptance of same-sex relationships, the acceptance of marriage between same bodily sexed individuals, we have to think about it in terms of undifferentiated social elements. So, within Native American society, there was a group of individuals who, and depending on tribe, it depended on how many genders there were. But within Native American society, there were multiple genders. So within particular tribes, you would have 2, 3, 4, 10. It just depended on the particular traditions of that tribe. But individuals were, their bodily sex was read through tribal logic. So American Indian societies, on the whole, we guesstimate that almost every Native society practiced this prior to colonialism, but that bodily sex was read through tribal cultural logic. And then as a result of an individual's behavior, the tribal cultural logic and the available social roles among these interconnected institutions, individuals were then fed into a particular social role, which was then attached to a particular gender. So if you look here, this sort of model that I've outlined, this is what gender would look like under a pre-contact, undifferentiated set of social elements. So an individual's bodily sex would be read by tribal cultural logic, and they would then have a ceremonial role, which would then be interrelated with an economic role, with a social role, and a political role. So depending on tribe, this is tribally specific when you get down to that, but for example, among the Lakota, there was individuals who were called winktes, and these were male-bodied persons who did the work of women, but also did men's work. They held an important ceremonial role as a mediator between people who are identified as men and women. Their social role, they had very specific social roles. Now, those social roles and gender roles and so forth were not devoid of an association with bodily sex, but it was different than Western ideas about sexuality, where bodily sex equals one or the other gender, right? So, again, this is important to understand what's at the root of the American Indian debate over same-sex marriage. So basically what happens is at the moment of colonialism, then you begin the 500-year decline of this practice of multiple genders, multiple sexualities. So basically, what happens is that Euro-Americans began going at the social institutions in which mixed gender, mixed sexuality identities existed. And so, I mean, they actually went after the people themselves. So people who presented their self as mixed gendered, they were persecuted as early as the Spanish conquistadors. But what you also have happen is that because these people existed in an undifferentiated social environment, their role was incorporated into every aspect of their tribal life, their daily tribal life. And so when you see a decline in ceremonialism through colonialism, then you see a decline in the overall participation and cultural contact within communities of mixed-gendered individuals. And so basically what begins to happen is that mixed-gendered individuals are no longer part of public Indian culture or public tribal culture for that specific tribe. And so that loss, the total cultural loss that occurred, has a significant impact on that. This changes the way in which tradition becomes thought of. So tradition is at the root of this misunderstanding, this idea of tradition, right? So gender slowly then becomes a differentiated social element. So when we talk about differentiated social elements, we tend to think about, in this context, Euro-American culture, where things like marriage is legislated, rather than simply an agreement among a community or an agreement between individuals. Or, for example, the separation between church and state. This is something that doesn't make sense in differentiated societies with differentiated social elements. So then what emerges, or the gender picture that emerges, is that in a contemporary Native society, you have what I call intelligible social roles, that bodily sex is read through a heteronormative model to where you have social roles or social activities, ceremonial activities that were at one time not necessarily gendered, become gendered. So again, this begins to alter the ways in which communities are thinking about tradition, or the ways in which communities are using tradition. So these cultural changes that are going on are also simultaneously, what you have going on is the institutionalization of American Indian social practices in terms of the founding of tribal governments, the tribal councils, Supreme Courts being established. The Cherokee, Chickasaw Supreme Courts are one of the first two. And Native peoples began legislating. This is working at the same time that individuals are attempting to maintain undifferentiated social elements. So I use my own tribe as an example. So among the Cherokee of Oklahoma, well, this was when they were still in Georgia, but you have the Cherokee courts being established, the Cherokee Constitution being written. You have a Cherokee newspaper. All of these institutions that are slowly being separated from community activities such as the stomp dance, which is the religion. So prior to that moment, the stomp dance and the political makeup of the Cherokee would have been intertwined. But because of the rigors required of dealing with colonial administration, you see this slow differentiation where tribal governments begin to act in ways that are in ways and in venues that are not necessarily part of undifferentiated social elements that traditionalists, or what I prefer to call cultural conservatives, are attempting to maintain. So in this context, the cultural conservatives are the natives that are attempting to perpetuate undifferentiated social elements at the cost of access to wealth, access to government, and things like that. And again, I'm being very general, and I realize that each tribe has its own story to tell in this, within this example. So I'm not trying to sort of rub out those differences. But one thing that happens, and is crucial to the debate about same-sex marriage in Indian country, is that marriage becomes a differentiated social element. So marriage becomes the subject of differentiated institutions and begins to be legislated, begins to have, so for example, the Cherokee passed the Defense of Marriage, their own Defense of Marriage Act, which I'll get to in like 12 seconds. So, and so basically what happens is that the making of same-sex marriage becomes a national question for tribal communities. It's moved outside of this undifferentiated social realm into the differentiated social realm. So one of the things that then happens is that when liberal activists become involved in tribal politics around same-sex marriage and the question of tradition comes up, they often rely on natives to provide an example of a sort of pre-modern golden time when native peoples were free and to, you know, where the men were men and the buffalo were scared. And so I got involved in this through the Cherokee same-sex marriage case, in which tradition was the key element. In this case, petitioners chose to try to block the marriage of these two women that I have a picture of here, Dawn and Kathy, based on the idea that a same-sex marriage would challenge the tribal council's ability to uphold Cherokee tradition. So I provided documentary evidence that, in fact, the Cherokee had some form of same bodily sex recognition of marriage or partnership. But what happened then is that, as a result, non-native GLBTQ organizations began to pick this up as a standard bearer for their own internal or their own fight over same-sex marriage. And so, inevitably, what happens is that what is an internal issue about sovereignty and the nature of sovereignty and tradition is then being co-opted by non-native GLBTQ activists, and inevitably it ignores the specific non-legal issues of being native in the U.S., such as political economy, social disenfranchisement in all aspects of American culture, and even social disenfranchisement of natives in the gay community. And inevitably, this challenges native cultural sovereignty, and as I would argue, is an act of resettlement. So, thanks. Was that 20 minutes? Oh.
You got a couple minutes left. Do you have a... I think it's the first panel I've moderated where everyone stayed within their time limit, so well done. We have time for questions from the audience. And before I take the question, I want to make sure to remind you and invite you for tomorrow's concluding event for Law Week. We're used to calling it Law Day, but we've stretched this out to almost the entire week. So tomorrow afternoon, right here at 2:30, this is particularly for students, we have a panel called Careers in the Legal Profession. And all three of our visiting justices have agreed to join this panel. And we'll also have members of the Dartmouth Lawyers Association who will be at that panel to describe their own tracks in the law, their career tracks in the law. That's at 2:30 tomorrow afternoon here. At 4:30, our concluding event will be a panel of 3 state Supreme Court justices, 2 who are sitting justices, one from Connecticut, Justice Joette Katz, and Justice Bob Cordy from Massachusetts, joined by retired Supreme Court Justice from Vermont, Jim Morse, who is actually in the audience today. Justice Morse and Justice Cordy are both Dartmouth graduates, so they're back at their alma mater. That is at 4:30 tomorrow afternoon, and Beth Robinson, who's a class of '86, will be the moderator for that panel. So please join us tomorrow afternoon. Following that, there will be a reception as a concluding event at the top of the hop, and we'll remind people of that tomorrow afternoon. So questions for our panelists, and maybe I'll start by seeing if you have questions for each other. Or not. Or maybe comments based on the other presentations.
Well. Professor Gardena?
Yep.
I appreciate your focus on status, or you say identity, over conduct as a way to turn the argument around and rebut Scalia's concern. I worry, though, that we're kind of buying into his game a little bit, And isn't there someplace, isn't the answer somewhere in the middle, in the sense that we ultimately do have to convince people that the conduct is morally acceptable as well? I'm just a little worried that it might be a mistake to distance ourselves completely from a conversation about conduct.
No, I mean, I think that attempting to talk about this in 20 minutes lends itself to some simplicity as a result. And I think that's right. I think that there's two ways, or probably more than two ways, but in the context that I talked about, two ways to think about it. One is, and I think a lot of people in the younger generation think about it in this way, as in gays and lesbians are just like everybody else, and I don't understand what the big deal is. And as you get into the older generation, it becomes much more about conduct, because gays and lesbians are identified by what they do in the bedroom. The reason that they're gay and lesbian is because of the type of sex they engage in. So I think it is going to be important to have that conversation about sexual conduct, and importantly about whether the government has a role in making moral judgments about the kind of sexual conduct that consenting adults engage in. So you're right to question whether or not focusing just on status or identity is the way to go, and whether we are bypassing important discussions about sexual conduct and the government's role in our sexual lives.
I mean, when you're dealing with the Native American case, essentially right after the Cherokee same-sex marriage case, their tribes, almost every tribe passed a Defense of Marriage Act within a week. And basically they were legislating whether same-sex sexuality was Indian or not, or whether it was Navajo or not, or whether it was Lakota or not. And so this is that identity question, and simultaneously they're using this idea of tradition, which is kind of like, I sort of equate it to the idea of same-sex marriage is un-American or something, right? And so this idea of tradition played heavily into the ways in which they were justifying that legal action within the tribal courts. And what was going on was basically tradition was being judged outside of culture history, and sort of became this pawn in the question about whether it was traditional for two men to have sex, or two women, or whatever.
Questions from the audience. Beth, and there's a microphone so we can make sure we capture this on audio.
Great. I just want to follow up on that, on Jackie's point and the conversation that she was having with Greg, because I was wondering, from your comments, is it your perception, you said we need to shift more to talking about identity rather than conduct. Is it your perception that advocates are talking about conduct in the context of marriage cases? Because my fear as an advocate in the marriage cases was the opposite, which is that we were desexualizing ourselves in an effort to so distance ourselves from conduct that we were doing ourselves a disservice. But I hadn't perceived that we needed to move more in that direction. See what I'm saying?
Yeah, I'm in full agreement with you. Yeah, I agree that that's the risk, that we need to embrace conduct or be comfortable with talking about conduct. And
I think he was suggesting that I was desexualizing, that by shifting the debate to status or identity was in fact moving it away from a conversation about sexuality and sexual conduct.
But do you think that shift hasn't already happened? Because I mean, do you feel like we need to shift?
I think the community or those advocating in front of courts are talking about it as status or identity. I don't think the courts are there yet. And my fear is that they won't get, if we keep it focused, or if the advocates keep it focused on sexual identity, that the tipping point, as I call it, won't be reached soon, because those that are on the bench tend to be those in the older generation in which sexual conduct is a moral issue and is appropriately legislated by the government.
And you'll be next.
Thanks, those were wonderful. Brian, I wondered, you did such an admirable job of staying within the 20-minute limit that you didn't have much time to talk about what you mentioned at the very end about how non-native liberal activists co-opted, your arguments against the petitioners in this case, and you called what liberal activists did a kind of an act of resettlement. Since I'm not familiar with this case and its aftermath, I wonder if you could just elaborate on that and fill us in on it a bit.
Yeah, and that was my intent, but I spent too much time talking about traditional versus non-traditional, because that was a really sort of key piece of my argument. But basically what happened is that two women in the Cherokee Nation read Cherokee marriage law, and it basically said marriage between two Cherokee citizens. So they took advantage of that, got married in the Cherokee courthouse, and then they went to file their marriage certificate. And the petitioners blocked the filing of the marriage certificate with the Cherokee court clerk based on that they were diminishing Cherokee tradition. And so tradition became, instead of making it an argument about sexuality, they sort of covered that, what their actual goal was with this argument about tradition. I was contacted by the Lesbian Rights Council to be an expert witness. And so I wrote an affidavit on behalf of the two women sort of presenting evidence. And so basically what happened is that the Cherokee Supreme Court found on behalf of the women, the issue that arose out of this was that had they filed the marriage certificate because of sovereignty law, that would have been a recognized same-sex marriage at the federal level. And so then it would have turned into a test of sovereignty, possibly. And so the women basically said, well, we're Cherokee first, and we don't want to challenge, we don't want this to turn into a situation where the Cherokee lose or get embroiled in this sovereignty battle, because what would happen then is with this it would be the only federally recognized same-sex marriage. And I don't think the Bush administration would have, because they didn't like Indians anyway, so that, they would have, I think that they would have challenged it. So, and basically what happened then is that became a very celebrated thing among gay activists, and I was getting phone calls from non-native gay activists, and what happened is that tradition, that question of tradition, became romanticized in the sense that, oh, natives, it's true, natives are accepting of GLBTQ people, and it is this, they did live in this gender, sexuality-free wonderland before Europeans, and so that was sort of that, it became an image, a symbol. And then when the Coquille recently in Oregon recently passed a tribal law accepting same-sex marriage, you had the same thing sort of happen, that gay rights advocates, gay newspapers, Out Magazine, online, were sort of presenting this as a success for GLBTQ people everywhere, while completely removing it from the political and social context of being Indian in the U.S. And so that's where that argument is coming from. So.
And then right here we had a question.
My question was for Dr. Gardena, and I was particularly interested in especially the title of your talk, just because I took a constitutional law course last year as an undergraduate, and one of the things I was really interested in as a same-sex marriage proponent myself, was the issue of ownership, and especially federal government ownership over issues like this, and how that can affect the legislation. And especially looking at, for example, like abortion law in the federal government, and especially in the Supreme Court, and how the sort of Roe v. Wade ruling, when you look at it, is actually kind of disturbing to read through the federal ownership of both the sort of physical, the body of a woman argument, and also the law itself, and that the result of that law was a lot of pushback from states, and especially state legislators and activists that we're still continuing to struggle with today. Whereas in like the sodomy laws that you were referring to, actually upholding the sodomy law resulted in a lot of similar pushback by gay, lesbian rights activists that ended up in a lot of states overturning those laws specifically that allowed for the later Lawrence v. Texas. And so, and I think also, when you look at old segregation laws, for example, how much support was there in the whole country before there was federal, law turning it over? It's a tough question. So I just wondered if you could talk a little bit more, I know you already touched on it quite a bit, about sort of how important or not you think, how involved or not Congress or the judicial Supreme Court should be in this issue.
Yeah, it's a great question, and DOMA does represent a departure from how the federal government has normally treated domestic relations. Both the Supreme Court and just Congress as a whole has thought of domestic relations, family law as largely and predominantly a state issue, and they've only kind of intervened to support it in some ways, like the Parental Kidnapping Act or other statutes like that. So this is one place in which DOMA actually has an opportunity to be overturned, because it is in some ways, and President Obama has talked about it in this way because he's advocating the repeal of DOMA. Because when you think about it, Vermont has said, okay, go ahead and get married, and we'll recognize same-sex and opposite-sex couples as the same. And the federal government, through DOMA, is saying, but we won't. We won't state, give your recognition, the same legal recognition on the federal level. So in terms of federalism, Section 3 of DOMA really kind of, Section 2, which is the non-portability, was seen as kind of enforcing state rights, because we weren't going to force states to recognize same-sex marriages heard elsewhere. But the Section 3 is actually a place where the federal government completely discounts a state's recognition of a marriage and says, even though you found it to be okay, we don't. And that's a departure that is pretty significant, and is probably one of the cracks that in DOMA that would allow the Supreme Court to at least declare Section 3 unconstitutional. I have no idea whether I answered your question. I kind of just went off on my own tangent. Okay, good. I'm glad it intersected at some point.
We have a question right here, I think.
Is this on? Okay. I was just wondering, it seemed to me that the California marriage case, in reading that it was more focused on how compelling the state's interest is in defending traditional marriage or traditional family structures. But the Iowa Supreme Court seemed much more focused on the relation of saying, well, whether that's your interest or not, this isn't going to get you there. You're not going to have more children raised by a mother and father if you strike this down, unless all the gay people say, okay, I'll just be straight. Am I seeing that correctly, that this is a departure? It seems to me like a way forward that can get us a lot further than the California court saying, well, that's really not a compelling state interest. Is it a new direction?
More toward identity or
Is this
Either
me
or.
Go ahead.
No, you go ahead.
Okay. So the question, to make sure I understand it, Kathy, is whether or not the California Supreme Court versus the Iowa Supreme Court was a move from conduct to status or identity.
Seemed to me maybe not so much on status to identity, although I say just win, baby, and they can get comfortable with sexuality on their own time. But I think, to me, it looked like the difference was the California court was saying that these state interests are not that compelling, they're not that legitimate. Whereas the Iowa court seemed to be saying, whatever the worth of that interest, banning same-sex marriage isn't going to push that state interest any further, so you might as well let everyone get married. Am I reading that correctly from those cases, the difference in analysis?
I don't know. I saw both of them. I didn't see the Iowa decision. First of all, is a fantastic decision, as you know. Boy, you read that thing, and it's so well written from a legal writing point of view. But I didn't see it. I thought its central mission was of the same caliber as the California, striking down any concern about intrusion on religion, and the welfare of children, and all those arguments were state interests that the court discounted. So I guess I'm not entirely sure of whether I agree with you in terms of a new direction in the Iowa decision, for it as ennobling as it was.
I think we have time for one more question.
Hi. When you were talking before about the focus on behavior versus identity, it made me think of something that I find problematic, and I'm just curious to hear your thoughts on it. Many people who support gay rights and gay marriage use the argument of choice, that people are born gay, don't choose to be gay, and therefore deserve to be protected because it's not a choice. And I think that this only actually hurts gay rights, because many people are born gay, and many people do choose to live heterosexual or homosexual lives. And I've read studies on it that were really fascinating about, more lesbians than gay men sort of align with the choice mode, that's not the right word, but you know what I mean. There's really a wide variety of how people see themselves and how they see, their lives and their identity. And I feel like by arguing that it's the lack of choice that really venerates the need for protection, it makes it seem like being gay isn't a valid choice. It's like, to me, I hear the negative side of that, of saying, well, there's no choice. And if there was a choice, of course, that's not what we would choose, but we can't help it. Whereas I think that if there was, I know it's not a choice for everybody, but if it was, if everybody just actually had the choice, I think that being gay would be a great choice for a lot of people to make. And I just wonder what you think of that. It's something that really gets under my skin, and sometimes I wonder if I'm just have this nitpicking thing, and I'd like to hear what people who think a lot more about the legality of it think about that choice argument, and if it's helpful or harmful.
You want to take that?
I'll start, but I'd like to hear your opinion too. Yeah, it's your last point that makes this problematic. The legality part here could be another instance where the law creates constructs that might not be in harmony with our own view of ourselves. Because, if you go all the way back to the concern of immutability in the law, and what that does to the level of scrutiny that courts will apply to statutes, you need to show that that this is an immutable characteristic in order to get into that elevated level of review. And it is also true, I definitely agree with you, it's amazing to me how many straight allies do base their opinion on that supposition, that this is not a choice, how can you condemn them for who they are. And I actually, it's funny you raise it, because it's been a little thing, so there are at least two people who let this get under their skin, because I think in the perfect world, if we didn't have that legal construct to worry about in litigation, yes, I think the most empowering thing would be to say, I choose to be gay. It's something, it's a volitional decision I made because of me, and it's a moral choice as opposed to something I'm just stuck with. So I agree with you, but we need to be cautious about taking that too far in the legal realm.
I don't actually voice this opinion very much because I think it might I don't want to undermine the reason that people are saying it's not a choice, because that might actually strengthen the legal argument. But I thought I would just like to hear your opinion on that.
Yeah, and I think that there is a danger on both sides of the argument when it comes to the legal construct. But going back to what Greg was talking about in terms of social and legal constructs, I mean, the idea of being gay or lesbian is a result of other people saying, well, you are having sex with someone of the same sex, therefore you must be gay or lesbian, you must be homosexual. It's a social construct, not necessarily something that the person would identify as themselves. And so I think that those lines are becoming more blurred, and I don't know socially whether they will eventually disappear. Legally, I think that the law has a really hard time with those kinds of blurred lines and the need for categorization and the need to say, well, this is X and that's Y and this is alike and that's different. I mean, we spend our whole time distinguishing or making things the same as previous cases. So the idea that we could kind of say, well, it is what it is, I think would be very hard for a legal mind to wrap their brains around.
Brian, any thoughts?
Well, I mean, this is a thing that comes up when we're talking about the difference in gender and sexuality traditions among natives, where you have sexuality as not being the most important thing about your identity, being part of community, cultural, conservative, traditional practices. So if somebody's participating in a ceremony, their sexuality is absolutely not determining their role. At the same time that you have these nationalist sovereignty agendas legislating sexuality. And so what was at one time sort of a haven for traditional communities or a haven for GLBTQ natives, now you're seeing these two sort of separate things starting to merge where natives are starting to debate this. Is it something that you're born with, or is it a choice, or is it contact with whites? This is the big thing now, is it that you're gay because you went to college over in Minneapolis and you had contact with immoral whites and you broke moral community, and so it was a choice that you made. You made a decision to be white, and by having sex with other men, and you bring this back to our community, So this idea of choice is, for natives, it's like choosing between Indian society and white society. So those two dichotomies are in traditional and non-traditional and those sorts of things. So to say that you were born with it, then you could maybe justify it in cultural history, but once sovereignty movements and traditional practice start to converge, then born that way and choosing are starting to get blurred in that way, and that legislation is starting to affect people in ways that maybe it didn't 10 years ago.
All right, I'm going to bring our proceedings to a close here, but please join me in thanking our panelists for giving us wonderful thoughts to think about, and please join us again for tomorrow afternoon at 4:30. But thank you, panelists, for joining us today. If you have further questions, please come up. I'm sure they'll be happy to take your questions in a more informal setting. Thank you for joining us this afternoon.